this ethical question. A question arose about one of the questions on the ethics test with regard to recording a conversation. I'll say this: it is legally permissible in Georgia to record a telephone conversation where only one party is aware of the recording, and so you can equate legally with ethical in this case. So I'll just leave it at that. Hopefully that's audio recordings. Yes, audio recordings. So anyway, first thing I wanted to mention with regard to sort of the best practices with regard to ethical issues. We had put together a list a few years ago that I wanted to mention to you before I talk about this issue that I've had come up recently, and then I'll touch back on those in a little while. The first, well, there's 6 of these. One is honesty and integrity. The second is respect for others, fairness, personal accountability, obey laws, regulations, and rules, and the last one is to be reasonable. I got a case. This is actually a case that I have going on right now. It's a real case. A fairly common fact pattern. The claimant sustained a back injury, and there was a recommendation from the treating physician in this case to do either a fusion surgery or, in the alternative, to do disc replacement surgery. And I wasn't involved in the case yet at that time. The adjuster had obtained an IME from another doctor who reviewed the case and said that this claimant was definitely not a candidate for the disc replacement surgery. Agreed that the fusion surgery was appropriate, but not the disc replacement surgery for this particular claimant. But as you might have guessed, the claimant and his attorney decide they want to do the disc replacement surgery. They get talked into it by the treating physician, and it's a complete disaster. It goes horribly wrong, and much worse than, way beyond the typical in terms of going wrong. And you know, where normally you may have a back claim that fusion surgery is required. And those are serious cases, but this one just got a lot worse and went way off the rails. And other problems came out of that, and one of the things was a psych issue. And the psych treatment really became the biggest issue going forward due to the frequency and expense related to the treatment. And so the adjuster, understandably, was very frustrated with this, and this was around the time that I got involved in the case. And we obtained an IME with a psychiatrist. And the psychiatrist, the IME psychiatrist had made some recommendations and said that additional psychological treatment was appropriate, but put an end date for what they were recommending. In other words, what they said was that roughly 12 months after the last surgery, and the claimant had undergone several surgeries to correct the problem with the disc replacement. And so the psychological IME had recommended roughly 12 months from the completion of the last surgery. And so we, as I would normally recommend with that kind of an IME, is let's send it to the treating psychologist and we'll see if they agree. So the treating psychologist received the report, presumably, but had not responded. And then over the course of time, because we were already several months after the surgery at that point, the claimant passed the 12-month time period that the psych IME had suggested. And unbeknownst to me, the adjuster just stopped paying for the psych treatment. And one of the adjuster had been pressing me about trying to get the case settled. And we had talked several times with the claimant's attorney. I think he kind of wanted to get it settled. The claimant definitely wasn't ready. And so the adjuster just stopped paying for the psych treatment. And it made me think about this talk here and the question of sort of aggressive claim handling versus getting to an ethical issue. And unfortunately, there's not really a bright line to to see there. It's I think the focus has got to be on the best practice tips that I had mentioned before. And I know in this case, because I've talked with the adjuster several times, I know that their motivation in doing this was to try to push the claim into settlement. And as those of you who've been around for a long time, you may remember an ethical question from our test last year or the year before. And the question essentially said, is it ethical to suspend the claimant's benefits to try to push the claim into settlement? Well, obviously it's not. And this really isn't any different from that. If your motivation for halting medical treatment, in this case there is some basis for it because you've got a psych IME recommending it, but certainly unilaterally making that decision to do that is not acceptable in my opinion. Again, there's no bright line. So anyway, I just wanted to go back and just mention these best practice questions, and then I have one other sort of housekeeping issue to mention. The items again, number one was honesty and integrity. If you tell the truth in your claim handling, you're really going to stay out of trouble most of the time. Respect for others. Judge Imahara was talking earlier about situations where you may be on the phone with him, but whether you're on the phone with a judge or the claimant's attorney or pro se claimant, have respect for them and their opinions, and I think that will serve you well long term. And one of the things we always tell our new associates too is you're going to be dealing with the same people again, so the way that you treat them will serve you well if you treat them well. Personal accountability, obviously you're going to be accountable for the way that you handle your claims and the decisions that you make. Obey laws, regulations, and rules. I think that one speaks for itself. The last two kind of go together. Fairness, try to be fair as much as you can, and try to be reasonable is the last one. Now I think in the situation that I told you about, I'm sure my adjuster could get on the stand and swear for the rest of their life that they had handled this case reasonably. I really think that they feel like we've been more than reasonable in all the treatment that we've provided. So, but I think you got to take all of these together. One last thing I want to mention with regard to the comments earlier that were made by Judge Imahara with regard to the PMT. One question I had, and unfortunately I was sitting in the other room at the time, was can we, as employers, insurers, can we use the PMT process as a weapon for us? Are we allowed to file our own PMTs? And he said that's not what it's designed for. I asked him out in the hall later. He said that's not what it's designed for. It's not set up to do that now. But apparently that is going to be phase 2 of that, and that's what he's trying to work in, because he admitted out in the hall it's really not fair that the claimants have the ability to push an issue quickly, and yet as employer insurers we have to wait 30 days, 60 days, or whatever to get a hearing if a claimant is not showing up for medical treatment or skipping out on physical therapy appointments that are delaying his treatment. What he did say that in the short term we should do is, he said if there's a judge already involved in the case, get that judge involved and just ask for a conference call. Or he said if there's not a judge involved in it already, he volunteered that we could call him, and I asked him if it would be okay with him if I had mentioned that here today. So if you have that situation come up with where a claimant is not following up with medical providers, instead of the usual situation we've had in the past where we have to schedule another appointment, see if they go, then file a motion, and then wait for them to respond to the motion and all this process that just takes weeks and weeks and weeks. This is a way that he offered that we can handle that now until this next phase of the PMT process gets put in place. So I did want to mention that as well, and that's really all I have. I think now is time for folks